Welcome to Coffee Chat. I'm Ashley Moscarello, and this is Maura Abernathy, and we're coming to you from Studio G with Goodman Law. Today's topic we're going to talk about is a popular topic that we get questions about all the time, and that has to do with boards taking action without a meeting. So let's dive into that, shall we?
Well, this is one of those areas where managers get a little nervous because they can be implicated if all this goes wrong. But the other thing is, although this is a popular topic, this particular issue is actually openly debated by attorneys. We actually internally debate this issue quite a bit and have sort of come to some popular consensus on this issue. And you know, managers need to remember that we're trying to keep the management companies and our clients safe from litigation, but this is probably an issue that one of these days likely needs to be litigated, but none of us want it to be one of our clients. So that's the key here.
That's the question. I think we need to put a colon on the topic today. Can you do it, and should you do it?
I think should you do it is more the question.
That's what we'll get into. Before we get into the meat of the issue, kind of just taking a step back, and we're talking about meetings of your board of directors. So what does it mean to have a meeting? Well, really, under Arizona law, anytime a majority of directors is discussing association business, that is a meeting. So you can see where you might run into some problems, because that means if there's a 3-member board and your 3 members go out for coffee and then start talking about association business, that's a meeting under Arizona law.
Any quorum of the board, it doesn't matter how informal it is, talking at the mailbox, technically that's a meeting of the board.
So the reason that gets boards into some trouble is because of the recent changes from the legislation last year in 2017, where they put kind of an exclamation point on the importance of having open meetings in homeowners associations. The legislature emphasized in a separate policy statement and in specific changes to the actual notice requirements for open meetings, with the emphasis being that when in doubt, have an open meeting rather than an executive session meeting. And if you are having an executive meeting, you have to state which section of the statute you are moving into executive for, such as for legal advice or to discuss a collections account of an owner or something like that. So that kind of leads you into the question, well, if it's so important that meetings of the board be open and when in doubt have an open meeting, that leads you down to the road of can you vote or discuss association information or take any action really over email with your boards. And this is kind of where the debate starts, because practically how in today's day and age, why wouldn't you? It's the easiest thing to just shoot out an email and have everyone respond, and that's that. And I think that makes a lot of sense, and I think that's something that maybe the legislatures are missing when they're crafting these kinds of laws.
Exactly, and the point is, what is action without a meeting? Email. Email is action without a meeting, but what we caution boards and management companies against is having a vote via email. So you got a 5-member board, 3 board members say yay to whatever action they want to take. That is improper, and that's not what we're saying. The action without a meeting, i.e. approving something via email, must be unanimous. And not only must it be unanimous, we actually advise clients to then ratify that decision at the next regularly scheduled open board meeting. It's easy to do. Keep the emails as either part of the minutes, or just include the action taken in the minutes. So either way, keep the emails or just make sure you have the action in an email. Think the boards should be okay.
That's right. And if you're wondering where that comes from in the statutes, it's not in either of the Planned Community Act or the Condominium Act. It actually comes from the Nonprofit Corporation Act. And a majority of the homeowners associations that we deal with are also nonprofit corporations, so they're governed by the Nonprofit Corporation Act. And so that is why, really, arguably, can you take action without a meeting? Yes, you can under the Nonprofit Corporation
But
Act.
this is where the debate comes in with attorneys, because they say, well, yeah, you got the Nonprofit Act, but the Planned Communities Act and the Condominium Act are more tailored towards planned communities and condominiums. So the Nonprofit Act wouldn't apply in that case. But that's where we come down on, well, of course it applies. An association is still a nonprofit corporation, hence the Nonprofit Act would still apply. So that's where we say it doesn't really conflict with anything in the Condominium Act or the Planned Communities statutes, even though they have a preference for open meetings. This still is a lawful act under the Nonprofit Act. So that's why we come down on the side of the equation that you can take action without a meeting. Again, just make sure it's unanimous. Make sure you ratify the decision at the next board meeting.
That's right. And so that kind of addresses the question of can you. I guess that leads us into the next issue of should you. What are some of the more common scenarios that we recommend maybe taking an action without a meeting? It shouldn't really be for, running the association over email and never meeting.
Definitely not.
It's not really intended to be that sort of use with action without a meeting. But I've seen instances where we need an answer on if the board wants to accept an offer from a debtor or from an owner in an enforcement action, and we need an answer within the next day or two, because of course everything in our office is litigation world. We need answers and we need to move.
And it's always on a Friday.
And it's always on a Friday without fail. So we need those answers, and we don't necessarily have time to work with the director's schedules, plus 48 hours for noticing all of the owners, and it can just get very messy that way. So if you can send out an email and get a unanimous board decision on that issue, we think that is valid. But should you be running the association over email?
Definitely not.
No.
Some associations, the reality is they meet quarterly. I have one association that meets once a year. You have to be able to, the manager has to be able to get board decisions, and this is really and truly the only viable way to do that in those circumstances. Plus, Ashley was mentioning needing board decisions for litigation. There's also other types of board decisions. Someone runs into the gate. If it's a gated community, monsoon storms created a lot of these types of situations this year because decisions needed to be made and there just wasn't enough time to even schedule 48-hour meetings. It just wasn't enough time. The manager had to act right there and then. But one of the things that we did want to discuss with this action without a meeting, and it gets a little tricky, but a director who's actually provided the approval in an email can revoke that approval. The deal is if that director revokes his or her approval before the last director provides his or her approval, then it's revoked. Then there's you can't take the action because it's no longer unanimous. So that's something to remember in this process, and that does happen once in a while. Someone does want to revoke their approval.
Yeah, that's a great point. And that kind of also leads us into one last distinction that we want to make. So I think maybe on a spectrum, if you think of all meetings, you have your open meetings on this end and then an action without a meeting on this end. Something that kind of comes maybe in between one of those is the emergency meetings. And that's also covered by statute in both the Planned Community and Condominium Acts. So if you're thinking in your head, well, if I'm voting via, making a decision via email without a meeting, what does that mean for an emergency meeting that the statutes discuss? So it actually comes up in the situation that you were talking about, where maybe you can't get unanimous consent from all of your directors
that
via
happens.
Email, which
it's always a holdout.
Yeah, getting everyone to agree on one thing, it's not easy. So That's probably where you might come into the emergency territory. The statute doesn't define emergency or give us any hints as to what that is, so it still is a pretty discretionary decision on whether it falls into an emergency category. But if you are calling an emergency meeting, you can meet under emergency circumstances without giving the 48-hour notice that's required for otherwise open regular meetings of the board. And if you do so, the board can meet to discuss only that emergency topic, and minutes should be taken at that emergency meeting. And those minutes should be read back into the record of the next regularly scheduled board meeting. So it's almost like a ratification
Exactly.
of an action taken without a meeting. So those are important steps to keep in mind if you are meeting under an emergency situation. And to make sure that you have all your ducks in a row for the next regularly scheduled board meeting, open meeting with proper notice given.
Yeah, and the last thing I wanted to say on this issue is, if you're a manager and you have a question, contact the legal counsel of that association, because as we discussed, there's actually still some debate over the statute and its applicability. So call the attorney who actually has to defend that action, because each attorney has a different take on this statute. I mean, we all say, for the most part, you can do it, just be judicious in when you use action without a meeting, but still, I would check with the attorney for the association. And that's what you need to know.